Second, democracy. Democracy is a fundamental value in our constitutional and political culture. Democracy enables the people of Canada to select their leaders and determine the nature of Canadian society and the Canadian legal system within the parameters of the Constitution. In institutional terms, democracy means that each of the provincial legislatures and the federal parliament is elected by popular franchise. The media in a democracy is not subservient to the government. The media, working in a transparent legislative environment and an open court system, is an important element of Canadian society and is an important protector of our legal system, constitutional government, and societal values. The military in a democracy is subservient to the elected government. It plays important roles, but it can never be more than a servant of the democratically elected government. Democracy has been defined by the Supreme Court of Canada as being fundamentally connected to the substantive goals, most importantly, self-government. The Court articulated some of the values inherent in the notion of democracy, and these include respect for the inherent dignity of the human person, commitment to social justice and equality, accommodation of a wide variety of beliefs, respect for cultural and group identity, and faith in social and political institutions that enhance the participation of individuals and groups in society. 3, constitutionalism and the rule of law. Constitutionalism and the rule of law lie at the root of our system of government. Constitutionalism requires that all government action comply with the Constitution. The rule of law protects individuals from arbitrary state action. It requires that all government action comply with the law, and most importantly, with the Constitution. Canada's courts have the authority to strike down laws and preclude government action that does not comply with the law, and most importantly, does not comply with the Constitution. That is a power that is used by our courts. At its most basic level, the rule of law promises to the citizens and residents of Canada a stable, predictable, and ordered society. 4, the protection of minority rights. The concern of Canada's governments and courts to protect minorities has been prominent in recent years, particularly following the enactment of the Charter. One of the key considerations motivating the enactment of the Charter and the process of constitutional judicial review is the protection of minority rights. The protection of minority rights reflects an important constitutional value in this country. Most of us are members of some minority in Canada. We know how critically important it is that society protect and respect its minorities. The 5th principle that I want to discuss with you briefly is judicial independence. It's a fundamental tenet of the Canadian judicial system. Under the Constitution, the judiciary is separate from and independent from the other 2 branches of government, the executive and the legislature. Judicial independence is a guarantee that judges will make decisions free of influence and based solely on the facts and the law. It has 3 components. Security of tenure. A judge is eligible to serve until the age of retirement. The judge can only be removed for misconduct or the inability to perform his or her role. The removal process is itself by an independent judicial process, not by the act of the government. And the government of the day cannot arbitrarily remove or suspend a judge. Judges have financial security and should be paid sufficient amounts so that it doesn't leave them in a position of dependence or subject to governments cannot change in Canada judges' salaries or benefits without first consulting an independent commission. And third, there's administrative independence. No one can interfere with how the courts manage their essential processes and exercise their judicial functions. As stated by former Chief Justice Dixon, it is only where the law is interpreted by an independent judiciary with a vision, a sense of purpose, and a profound sensitivity to society's values that the rule of law, and therefore citizens' rights and freedoms, are safe. Canada has been successful in selecting and appointing independent, well-qualified, and professional judges. The judges of the Supreme Court, the Superior Courts, and the Federal Court are appointed by the federal government. Instances of patronage have decreased considerably over the years. Instances of judicial corruption or impropriety are extremely rare. No judge has been removed or suspended due to political pressures or other arbitrary influences. We are a nation in which the integrity of the judiciary is steadfastly upheld. Both civil and criminal litigants can be confident that at the very least their cases have been heard and fairly considered in accordance with the law and based on the evidence. Even the appearance of bias or partiality is strongly guarded against. There are, however, some challenges to judicial independence in Canada. For example, there is occasionally talk of introducing parliamentary review of judicial decisions and calls for appointment procedures that would permit legislators to choose judges on the basis of political ideology. Occasionally we see members of the media or the occasional elected representative, in my view, unfairly and aggressively criticizing judges or the judicial system itself because of particular court decisions, to the point where it sometimes appears to be infringing on judicial independence. Our experience in this regard has been mild compared to what occurs in some other countries, but is unacceptable nevertheless. Canadian judges and Canadian lawyers as a whole rightly consider themselves guardians of the legal system and the rule of law. They have resisted and stood firm against pressures on judicial independence. It is also incumbent upon the media and on all citizens and residents of Canada to be ever vigilant and to guard and protect our legal system and the rule of law. The principles I have spoken about embody the fundamental assumptions that underlie Canada's Constitution and legal system as a whole, and they inform the analysis for evolution of our written constitutional text to meet new social and political realities of our expanding and increasingly diverse population. We are privileged that Canada relies on an evolutionary, not a revolutionary model for the development of our country and the development of our legal system and laws. Our constitutional history illustrates that our governing institutions have adopted and adapted what we have seen elsewhere as suitable for our society, and adapted and changed to reflect changing social and political values and realities.